Peter and Yassi and I, Patricia Afterheide, we're presenting a webinar focused on the part of the Code of Best Practices in Fair Use for the visual arts that deals with museums and collections. We are sincerely hoping that you have attended the earlier webinars, or some of them, because unlike the earlier ones, we are completely breezing through the entire description of fair use, and we are going to be focused on working with you on particular problems in museums and collections and getting your questions and your reactions to how to employ the code. So first of all, I'm sorry?
I just would add to that, if I may, that one of the reasons, in addition to the fact that you're all old hands by now, one of the other reasons that we're taking this approach is because we think that the code has potentially quite enormous for practice in the museum sector, and we're very anxious to pursue them.
Absolutely, and don't forget that you can go back and revisit these earlier webinars as well. So we're going to basically do a quick touch on why fair use is important to you if you are in museums and collections practices. We're going to give you the quickest of refreshers on fair use. We're going to then go to the Code of Best Practices, and we're actually going to visit the website and read the code, the sections of the Code of Best Practices that deal with museums and collections, and we are then going to do some testing of our knowledge together. So briefly, I think anybody who works in museums and collections is familiar with the problem of copyright, and in daily life, more than 3/4 of you said that you face these problems every day. But a third of you, more than a third of you, actually also said that you had projects that you had either avoided or abandoned because of rights problems. We also know that almost everyone in this field has had problems with delay and with higher costs than they either anticipated or think are appropriate because of copyright problems. So this adds up to this familiar problem of self-censorship, and the reason we say self-censorship is that we are keenly aware that although the law permits you to do many things, your concerns, which are legitimate, about the reputation of your institution and your own reputation, the concern to maintain good relationships with your suppliers and with artists, and a legitimate concern about will you actually be in legal trouble are part of the reason why you hesitate or even say, let's not think about doing that. So this is the part of the law that permits you, and has always in your lifetime permitted you much more latitude than that, and Peter is going to give us a very quick refresher on it.
Thank you, Pat. And the quick refresher really consists of a few important propositions. One is that the fair use doctrine is venerable. It's been around for a long time, 175 years or so, but it has only recently, within the last 25 years, really come into its own as a critical balancing feature in the copyright law of the United States. A balancing feature in the sense that it's one of the structures within copyright law that assures that rights holders get a reasonable level of protection and that all the rest of us get a reasonable level of access so that we can build new culture on old. And among other things, it's also been recognized recently as having a kind of spiritual origin, so to speak, in the First Amendment. This fair use doctrine is in effect the way that First Amendment freedom of expression principles get operationalized in copyright. What makes this a historic and very positive moment in the history of fair use law? Well, essentially the following, that after some years of confusion about how to interpret the famous 4 factors in Section 107, the things that the statute instructs us to think about when we are deciding whether a use is fair or not, the courts in the last quarter century have really boiled it down to 2 critical questions. And the first question, which a court would ask after the fact if a use had been challenged, and which we need to ask before the fact when we decide whether or not to engage in a use, is, does the use have a transformative purpose? That is to say, is it addressing a new audience different from the one to which the original material was addressed? Is it trying to accomplish something different from which the source of that original material had in mind? And if so, then the use is considered transformative. In that case, there's really only one question left to ask in practice, and that is whether or not the amount of material used is appropriate to the transformative purpose. Now, occasionally you hear that there is no, you can never use a whole work under fair use, but that's just wrong. It's never been correct. Instead, the question, regardless of the amount you use, that the court is going to ask is whether or not the amount used is appropriate to the purpose. And if the answer to those two questions is, in each case, affirmative, then statistically speaking, the use is almost certainly going to be considered a fair one. There's also something else that comes into play when courts think about fair use issues after the fact of a use, and therefore also when we think about fair use issues before the fact of a use, and that is, what does the field think? There's plenty of evidence, well documented, that when courts encounter fresh and challenging fair use questions, they want to know whether or not what the user has done is conventional or within the definition of the members of the field as to what is appropriate. That's what the slide refers to as custom and practice. And obviously that information, what people in the field think is important and appropriate in order to accomplish their particular missions, that's going to be particularly powerful information if it's well documented. And that kind of documentation, or the production of that kind of documentation, is really what this best practices project, of which the CAA Code of Best Practices for the Visual Arts is a part, has been about over the last decade in which we've been working with it. And there
so
it is.
we are going into this Code of Best Practices, which is a way of distilling for you what your field believes, your creative community believes is appropriate. And that's appropriate irrespective of whether it is currently common or not in your field. And just really quickly, there are some obvious traits to this that are very, very different from the checklists, the flowcharts, the industry permissions that you are used to. First of all, this is not going to give you bright lines, and it should not give you bright lines. It should give you a way to think about your rights just like your other rights. And you don't want bright lines because every situation that you're in deserves the same logic applied to it, but not necessarily the same rigidity of number of pixels or number of seconds or number of words. And this is firmly grounded. This is not a legal document. This is a document about what people in your field believe is the best way to proceed. And in that is exactly the reason why it was never negotiated with people who don't need to do this work that you are doing. In other words, estates, brokers like ARS and Vaga, large content holders, because it's not their job to do things like curate exhibits or put up collections or do other kinds of curation, explanation, educational missions. It's their job to make access available to their stuff. And they have their own issues. But your issues have to do with what's the responsible way to use this part of the law to do the job that you need to get done. And that's why this code is that kind of professional consensus. We have a couple of things that come up frequently, so we're just going to mop them up right now.
All right, let me start with that. The first thing is that fair use in the discussion that we're having now is about copyright. It's not about other kinds of intellectual property law. Sometimes people get confused about copyright issues, which can be very real and important to think through in various fields of cultural practice, educational practice, or creative practice. They get that confused with trademark issues, and trademark issues are, frankly, trivial and inconsequential in these contexts. Generally speaking, museum personnel, creative artists, teachers, and others in the visual arts simply don't have to worry about trademark law. If you want to read more about why that is so, you can do so in our frequently asked questions document, which you'll be given a link to in a little while, but breathe easy. There are no trademark issues to speak of here. There is, however, a different problem, which is real despite fair use and independent of copyright, and that is that sometimes you are dealing with an entity, an individual, or an estate, or an institution that is the only source for the material you want, that has the only, that controls the unique original, and that rations or refuses to make available adequate digital or other copies and reproductions of that material. Well, that's not a copyright thing. That's a thing that grows out, that power, that authority, so to speak, grows out of the hard, irreducible fact of possession. And when you're dealing with a sole source entity of that kind, you are more or less at their mercy, and there's really not much that a copyright doctrine like fair use can do to solve the pain. Copyright works well when you have, or copyright fair use works well when it applies if you have access to the materials that you want to make use of. It can't give you access to those materials. And so the so-called permissions fees that museums, for example, sometimes charge in order to provide digital files representing collections and their material, of their materials, may sometimes be unavoidable. Now, whether museums want to charge those fees as a routine matter, or whether they want to join what I covered is a trend away from imposing routine permissions fees of that kind, is of course a matter of institutional choice, but it has nothing literally to do with copyright or fair use.
So, and I'm hoping that you guys are not having trouble seeing these slides. If some of you have the option to expand the PowerPoint, the picture of the PowerPoint, if you're working with a tiny little postage stamp in the middle of your webinar screen, I think you do want to expand it because you're going to want to study the examples. But the structure of every situation here is the same. There's a description of the basic logic of the situation. There's a description of how the principle of fair use applies, and then there's the crucial part, which is at what point would this stop being fair use? And that's the part that really helps you understand what fair use is to say within what limitations does this occur, because fair use doesn't mean you can just take anything. It means that you can take stuff that is repurposed and appropriate to that repurposing. So those limitations are going to be really critical to you, and we're going to go to that in just a moment, but first Peter's going to give you the quickest of overviews of the issues before we read them in the text itself.
Thank you, Pat. And I want to reiterate that when you're making use of this document, as we very much hope you'll consider doing, you need to read those three parts of the statement of each proposition as an integral unit, because the description gives you the scope of coverage, the principle gives you the general proposition that fair use applies, and the limitations give you the metes and bounds, the extent of the application of fair use. And the description of museum uses in this document, in Principle 5, is extremely dense, intentionally so, and broad, and it covers such things as the use of copyrighted works in both physical and virtual exhibitions, the provision of online documentation, the use of copyrighted imagery and text where appropriate in brochures, guides, and catalogs, the reproduction of copyrighted material in museum-generated educational material, and much, much more. So
we are just going to take a quick look at what that actually looks like, and I'm going to model for you now how to get there. I'm going to my site because I'm most familiar with it. You might want to go to a CAA site where you would enter collegeart.org /fair use. I'm going to the Code of Best Practices, and I'm going directly to museum uses. You can see, as Peter said, the description of the many ways in which museums have missions, have jobs to do that might touch upon fair use is really long here. And it is deliberately written, believe me, so much work went into thinking about every phrase here. It is deliberately written so that it can encompass the many, many different kinds of things that you do. Here is the principle. Please notice this little colon right here at the principle, because that is the colon that links this to limitations. But the principle says that in all of these many diverse things that you're doing, you have a right to think about whether fair use applies. And when you think about it, here are limitations that would apply to most of the things up here in description. And as Peter said, this stuff, and this is why I told you to expand your view, because otherwise you can't even read this. But take a look at those limitations, because they are going to really be able to help you. The first one says that and this is totally obvious, but when you're thinking about whether fair use applies to a copyrighted work, you should have some curatorial objective for choosing that copyrighted work rather than some other one. And you should be able to say, if you had to, what that purpose was. And the amount or the size or the resolution or the level of fidelity, make that appropriate to your educational purpose. If that fidelity needs to be very strong for that educational purpose, you probably want to think of why that is, but if you can think of why you need to have that level of fidelity, that's a completely defensible reason. We had a lot of discussion in many groups about how available these works should be. Should they be, if they're shown online, should they be made available for download? Should they be made available at what resolution on download? And people decided that if they're going to be downloadable, make them big enough to be usable in PowerPoints and displays and it's just for study on a personal computer, but don't give them an incredibly high level of detail.
If I may jump for a moment.
Yeah, and I'm going to leave the rest of them to you, Peter.
Okay, thanks, Pat. To jump in for a moment, let me note first that on these second and third bullet, you'll look, but you won't find. You may look for, but you won't find concrete metrics. You won't find pixel numbers. You won't find other indications of permissible or, by implication, impermissible image size. And that, again, is because the groups that we talked to, and these were groups of hundreds of people from throughout the visual arts world, including many working artists as well as museum professionals. They felt strongly that these issues of image size were moving targets, that the appropriate size of an image changed both with the context of use and over time with the expectations of the larger community, and that therefore, rather than metrics, which have, of course, the value of certainty, it was far more important to have analytic standards that could be applied in different situations and at different times. And this is what they came up with. There's also an interesting and specific limitation with respect to the activity in which some museums engage, and that is of providing users with very, very, very large image files in order to facilitate detailed analysis and other forms of close looking. And you can see here that it was the consensus of the group that although that's a fine practice, those files ought generally not to be downloadable, but instead should reside along with the tools that make it possible to use them on the museum's servers themselves. Attribution is something that's important. That's important throughout this document and throughout all the other fair use best practices documents. It's something that goes in the visual arts community very much to the heart of whether or not users feel that a particular, members of the community feel that a particular use is being made in good faith. And the same is true of the provision of a reasonably appropriate level of metadata. What's appropriate and available is obviously going to depend on situation and circumstances. And finally, of course, there is at least some concern about the possibility that there may be special cases. For instance, if a museum holds a good deal of ethnographic material, there may be reasons to think again about the sensibilities of the indigenous communities or others from which that material originates before making decisions about whether to put them or to put that imagery in its entirety online. And again, this isn't a core copyright concern, but it is a concern that goes to the question of what constitutes the good faith exercise of fair use, and that is a core copyright concern.
So as long as we are on the website, I want to point you to as well the next segment that we will be discussing today, which is your collections. Some of you in museums have collections. Some of you are from archives that mainly have collections.
And by collections here, we mean collections of things other than primary collections of art objects. That is, collections of supporting documentation of all kinds, and including precursor materials, manuscripts, financial records, and all the other things that are listed in the description, which is once again worthy of study because carefully crafted.
Great. So again, this description, the principle with that magic colon, I love punctuation. It's so crucial. And that punctuation, it leads us from fair use is eligible to you when you have these collections of manuscripts, records, photographs, book collections, etc., of your artists. But here are the limitations. And Peter, do you want to make a 2-minute sweep through the limitations before we start the questions?
Yeah, the first of those limitations actually relates to the very last of the limitations in the previous section. That is the importance in making decisions about putting material from collections of the kinds we've been discussing online, of giving thought to and following professional standards about the protection of the individual privacy of living persons, or in some cases living communities. Another very important issue, and it was much discussed in the groups, was to what extent the institution that made material from these collections of documentation available, for example, online, should be responsible for what individuals who come to that material and obtain it at the museum site actually do with it. Now, it's perfectly clear, and again, this is explained more fully in the appendix that follows and in the questions, the frequently asked questions appended to the document online. It's perfectly clear that as a matter of legal doctrine, an institution that exercises fair use and good faith to make copyrighted material available online doesn't have legal responsibility for what people do if they misbehave with that material. But there was a strong feeling on the part of the groups that there was an important ethical responsibility to let users of material found on their sites know that it was those end users' responsibility to comply with copyright. The third bullet is also...
Yeah, in 1 minute, we have to wind it up and go on to the next.
The third bullet is an important one in that it reflects the shared sense of all of the groups we have that communication between institutions that choose to put material up online on the one hand, and those who have questions and concerns about that material or information to share, including but not limited to copyright complaints, have an easy, convenient, well-labeled way to do so. And then, of course, we've got attribution and metadata, and about those there's really no more to be said than has been said already. And that's it.
Wonderful. Well, we are now moving on to a set of questions, and we're going to start with our friends in the ancillary collections. So, and I hope that everybody has expanded their PowerPoint so that they can read this. But we are about to give you a set of scenarios, and we are at a museum that's non-endowed and it's non-profit, and your museum has related archives, and you've just purchased at an estate auction, you've purchased some papers from a 20th century sculptor. And so you have a wide assortment. You have some sketches, you have letters so this is correspondence to her and also from her. You've got photographs other people took and you don't know who they are perhaps, and you have other work, you have gallery catalogs, you have contracts. Now people have gone through and sanitized this information for personal information and other information that the estate did not want to make public, or that you shouldn't make public. So you don't need to worry about that. But the question you're going to... I'm sorry. I'm sorry, Peter?
I was saying just the privacy issues have been taken care of.
Great. And so the question we are now going to ask you to vote on, based on the part of the code that you just looked at, the collections part, with its limitations that Peter was going through for you, is, do you have the legal right to use fair use to post this collection digitally? And Michael's going to launch the poll for you. You've got 3 choices. Thank you for leaping in here. I'm so excited that we have so many people participating today. It's really great. Okay, make your decision if you're going to vote. We've got 74. I don't know if we can get up to 80, but it looks like we might be at 3/4. Okay, so thank you, Michael. It looks like a few of you are like, no. The majority are, yeah. 2/3 of you are, yeah. And then we've got another quarter who are just really not sure. And Michael, can you access questions? Can people put up the reasons why they either said no or what's making them unsure about whether they can put up that stuff? Pete, but you'll have to tell us what the questions are because.
And no questions yet.
Okay.
So while we're
Folks,
waiting, let me say one thing in defense of the I'm not sure's, which is that I'm not quite sure either, because the example, although it was pretty detailed, wasn't detailed enough to make clear whether all of the limitations of the code were being complied with. There are the attribution limitations. There are the metadata limitations, and then crucially, there's that limitation that has to do with providing a link, a button, an easy way for members of the public to get in touch with questions and concerns. And those would, in my view, be important elements of compliance that might make the difference between an I'm not sure on the one hand and a yes on the other.
great. So
Pat, I have
any
a
other?
few. Pat, I have a
Yes, go ahead.
It was photographs of others' work that made one of us unsure. We're assuming, of course, that we follow the advice in the limitations.
Yes.
Since the artist is still alive, their state of being, oh, I'm sorry, that got cut off, as well as the, okay, last one here. I was just unsure about whether the foundation or estate gave legal disclaimers along with the purchase of the items. I've worked with foundation documents that specify exactly how something purchased can be used by the buyer.
Great point.
That's such an important observation. The answer with respect to the problem is no. We're assuming that this is a naked purchase, but it is absolutely true, and the questioner makes an extremely important point, that if a donation agreement specifies what can and can't be done with donated material, then of course that donation agreement, as long as it's in place, is the last word, which is a good reason, incidentally, when you negotiate donation agreements, to try to do so in ways that provide the institution with the broadest possible scope for legitimate use. To go back to an earlier question, there is nothing in the structure of the principle, and there was nothing in the discussions that gave rise to the principle and the limitations that would suggest that the presence in such a collection of images of third-party artwork would in itself make a difference. In other words, if we are trying to present a rounded picture of the intellectual life of artist A, and if that rounded picture consists in part of providing images of the work of artist B that artist A thought important enough to collect or to memorialize, the fair use rationale ought to apply with equal force to those images as well as those of the artist in whose collection they are found.
So this is actually a really great example of the importance of context and the meaning of transformativeness. Because why are those pictures of somebody else's artwork there? They're not, you wouldn't be putting them up in order to secretly exhibit somebody else's artwork. You'd be putting them up because somebody kept them. Maybe this was in some collection of photographs that the sculptor was studying. Maybe the gallery owner sent the sculptor some pictures of somebody else's work, saying, "Did you see what they did? Are you interested in meeting this person?"
Or maybe the sculptor's breakthrough exhibit was an exhibit that included the work of other related artists.
Great example.
Many possibilities.
So, in other words, any one of those is a transformative reason for why you're showing the picture.
I would also add something that we stressed earlier, and that is that if you do this, and we think that the code provides a very, very robust basis on which to do it, you need to be prepared to explain yourself. You need to be prepared to offer, if queried, your rationale for what you did and why you did it. That's, in a sense, the price of admission to the healthy exercise of fair use.
Michael, do we have any other questions before we move along?
There are a few more.
Go ahead.
Okay, 1 second, let's see. Photos of other still living artists' work and gallery catalogs. How can you guarantee permission for these?
Well, that's such an important question, and the answer is you can't because you don't need it. The whole essence of fair use is that where fair use applies, permission is not required. Fair use is the other face of the coin of permission, so to speak. So the Copyright Act is very clear. It says where fair use applies, an unlicensed use of material or use for which there is no express permission is not infringing. So fair use is the obverse of permission.
Great. Okay, keep on going, Michael.
Wouldn't it behoove the institution making the materials public to be in touch with the estate from whom they purchased the materials?
That's an extremely good question, and without knowing the details that we didn't supply, it's hard to be sure. It's a question that implicates something that I think runs through all of this material, which is that there is a distinction between what your legal rights are, which is what the Statement of Best Practices is designed to address, and what is, in a given situation, polite or prudent or otherwise advisable. And there are certainly going to be situations in which, rather than exercising fair use or before exercising fair use, you may want to be in touch with someone as a matter of politeness or in order to create or to sustain a relationship with that other person. That's particularly true, of course, of living artists and the estates of recently deceased artists. Those are, as I say, prudential considerations for an institution to make once it understands what its legal rights are, which is what this exercise is designed to address.
Okay, last couple of questions. Michael, why don't you give us all the questions that are there so we can lump them together?
Can we legally use fair use to post a collection of art-related documents that were obtained in other countries where their national copyright law protect the rights of reproduction from the authors?
Got it. Okay, keep on going.
If I obtain an image, digital or otherwise, of an image that is controlled by ARS or an estate, can I use it in a scholarly curatorial publication, analog or digital, without incurring the wrath of said organizations?
Yes, okay. We're gonna turn that one back to the people who to the last webinar, which was all about scholarly publication, and
also, it comes up a little bit when we get to exhibition activities and catalogs and so forth,
right,
which are coming up
but we also really want you to go watch the scholarly publication. Okay, keep on going.
One more. Would fair use apply if the institution was not a nonprofit, say a proprietary school?
Great. Okay, so Peter, the two questions we need to answer are the nonprofit and the international.
Yes. And the answer, let's take them in reverse order. The answer is yes, it would apply. There is no limitation to nonprofit organizations written into fair use doctrine. That feature of the problem was a bit of a red herring, and I'm glad that you caught it. The whole point of the approach to fair use that the courts follow these days is that it applies even-handedly without regard to the commercial or non-commercial character of the use. Now, that's good news, and there's also good news about the question having to do with material that comes from other countries. Because the way copyright law works in the international environment, it's the law of the country where the use takes place rather than the law of the country where the material originated that matters. So if we're talking about a U.S. museum doing something on its U.S.-based website with its U.S.-based server, the answer to that question is you really don't need to worry where the material comes from.
Okay, so we're going to whiz forward here to the curatorial work of museums. So I'm now giving you a new challenge because you are working in a team that's mounting an exhibition from current era Occupy movements. So you've got all kinds of ephemeral stuff, and some of it's video, some of it's street art, some of it's posters, some of it's graffiti. And so it comes from a lot of different places. Some of it's born digital, and in a miraculous situation, because we got to write this scenario, you've just no problem with the access to all this material. You've got access to everything.
Well, you went out and gathered it yourself in the street.
There you go. But the question here is, given the terms of the code, can you legally employ fair use to show it in the exhibition as well as a catalog? And this catalog is going to appear in both digital and print form. So that's the question. And Michael, can you launch the poll? Okie doke. We only have another 15 or 20 of you to make as many as the last time. I know you can do it. Keep on going, guys.
It's too early to be fatigued now.
All right. One more person. Come on in. So this one you're less sure of than the last time. You have about 2/3 of you. No, I guess it's about the same. About 2/3 of you say, yes, I can do this legally.
Pretty close, actually.
Yeah, and there are more no's than last time, but there's also about 1/5 of you who are not sure. And again, we really want to see the reasons why you're not sure or why you say no. That'll help us to work through the problems that you're having with the code. So please let us know.
I'll again say that I've got some sympathy for the not sure group because, among other things, in order for this to fit comfortably within the principle 4 of the code, there would have to be a good faith effort to provide the most complete attribution available for this material. And that'll be some work. That won't be necessarily a trivial effort given the complexity of the material involved. Now that doesn't mean, of course, that some material won't remain stubbornly anonymous and that by virtue of that fact it cannot be exhibited. It means that you've got to make a good effort where something isn't designated anonymous at the source to figure out whose work it is.
And Peter, can you document that in the material that you provide, saying this material came from this place and we're unable to determine who?
Oh, absolutely. That would be an extremely good practical surrogate for a named identifying designation. And again, there may also be your question is a good one, Pat, because among the kinds of metadata that it would be appropriate to try to provide would be some indication not just of who made this thing, but of where it was made and the occasion in which it was made, since obviously the art we're talking about is politically contextual, politically and geographically contextual.
So, Michael, can you tell us what people have put up as questions and comments?
Sure. The first one, yes, because it's found material that was created as street art. We think
read us as many as you can.
We think yes for the exhibit, but no for the catalog. Will the work or the catalog be sold? Especially with a group like Occupy, I would be nervous of generating profit based on this social work.
And anything else?
Not enough information. Wouldn't we need more information for the catalog, knowing attribution, size of images used, etc.
We've talked about that a little bit already.
Okay, keep on going.
One of us thought yes for the exhibition, but wasn't sure about the catalog. Another was thrown by the time-based material.
Uh-huh. Does it say why?
No.
Okay, keep on going.
For the born digital art, it could be infringing on artists' copyrighted work, particularly for the ebook.
I see. So again, this is a question about the catalog. Okay, keep on going.
If you stand to profit monetarily from the use via the publication, how would this fall under fair use?
Okay, for-profit issues. Okay.
Could we stop here and do these and then perhaps do another
Great. So two of these questions, Peter, deal with the question of what if you're selling what if you're selling some of this work? And of course, I'm presuming that this museum, which is nonprofit and not endowed, is probably also charging for entry. So there is money changing hands here. So could you address that first, and then I can cue you on the other ones as well.
It goes back to something I was saying in response to a question on the last round, and that is the way that the fair use doctrine has been reimagined, and I think reimagined is a good term, by the courts in the last quarter century, essentially removes most, if not all, of the significance from this distinction between profit and non-profit, between commercial and non-commercial. The two questions are whether the use is transformative, whether taking art out of the street and putting it into a gallery with an appropriate amount of contextualizing information, or into a catalog with even more contextualizing information, is or isn't a transformative use. I think it's probably pretty clear from the case law that it would be considered a transformative use. And then the question is, well, have you used the appropriate amount of material? And of course, in most of the cases that we're talking about, the appropriate amount is going to be the amount, both in size and in quality of image, which adequately illustrates the propositions that the exhibit or the catalog are designed to demonstrate. So commercialness, profit, those things really, those diminish almost into the vanishing point, where you have transformative use in appropriate amounts. Likewise, and this runs very, very strongly, not only through the deliberations of the groups that produced the code around these or around this principle, but really around all of the principles. And it is important to read the code as a whole and not just to focus on the principle or principles that are directly relevant to one's own activities. Again, the feeling among these groups was very, very strong that discursive uses of material, uses that added value by way of explanation or recontextualization, which would include a serious catalog, are not only examples but strong examples of transformative use. So
Peter, we have I'm sorry.
No, continue, please.
We have three questions, all of which deal with the catalog, and one feels that the catalog is just in a different category. One says, wouldn't we need much more information on this catalog? And the other one says, what if we publish somebody's work? Wouldn't that be infringing?
Well, again, as I've been saying before, if you look at the code around this issue, and then also if you look back at the related principle about scholarly communication, it's very, very clear that the code stands for the proposition, I believe it does so correctly, that the catalog is an excellent example of transformative use. And of course, there would also be responsibilities on the part of anyone preparing a catalog to provide appropriate metadata and to provide appropriate attribution. There's one other thing I would say here. I keep talking about what the fine arts professionals or the visual arts professionals who came together to make the code thought, because that's the essence of the code. But it should be remembered that what they thought, and we acted as far as we could as their faithful amanuenses, what they thought and what we recorded was then vetted by 5 very, very tough-minded copyright lawyers, including at least 3, perhaps we really should say 4, with direct experience of the museum world, all of whom felt that the conclusions that the community had reached fell well within the current legal framework of fair use case decisions. So
we have 5 minutes left, and I'd like to get to one more question, but if you could quickly deal with the 2 final questions. Time-based art, is it different under fair use? And does the fact that this was out in the street make a difference?
The fact that it's in the street makes no difference. It doesn't help or hurt the arguments, except that, of course, it makes it easier to get the images which one then wishes to reproduce. In the case of time-based art, I think it's an issue that someone who is compiling an electronic format work should definitely consider, and you can see more treatment of that issue in the related principle on scholarly publication. And the question will be, for purposes of this exposition, is it important that the entire time-based work be exposed digitally, or are the expository purposes of the catalog sufficiently served by a representative portion thereof?
So we're going to move on to another question. I'd love to put the whole thing online. How does that work under fair use? And so Michael, could you
about a physical exhibit and a print and electronic catalog. Now we're thinking about creating a corresponding virtual exhibition.
So can you vote? Yeah, Michael, could you launch the poll? Okay, hop in there, click. Thank you. Okay, so the majority of you think, the vast majority of you think yes, but almost everybody else is not sure. And Michael, has anybody shared why they're not sure about being online?
Not yet.
Okay, then you know what we're going to, Peter, do you want to make a comment before, because I was going to move on to the next question.
No, the only comment to make is that, honestly, everything we've said before is redoubled here, because the code does not make a distinction between physical and online exhibits.
And I don't believe that, I think that one of the big demystifications for me in getting to learn about fair use was that fair use applies across the board for all kinds of media. It's the same logic for all kinds of media, and it's the same logic for all kinds of platforms.
A unified field theory.
Love it, at last. Okay, how about this poll? We want to give pictures to the press. Can we use fair use for that?
In advance of
publish the pictures on their blog.
One of you said that your practice was to pre-clear rights in all exhibition-related materials that were provided to the press in order to encourage or to enrich press coverage. And we found that quite interesting and wanted to know what all of you think. It's not literally dealt with in the code, so here we have to extrapolate a little bit. Again, the question is it a transformative use?
And in this one, we have so far everybody going to vote? We've got a lower percentage of voters here, and I'm wondering whether we have a very high proportion of not sures and a significant proportion of no's. And we are not going to have time to take your questions on this. So Peter, would you like to round this out with a comment on this one?
I think I can, yeah. I think I can say that an activity of this kind, which is ancillary to an otherwise legitimate museum function, like putting on an exhibition that is transformative in the sense that these images are being provided to the press in order to promote coverage rather than simply for directly exploitive purposes, that would, I think, in most people's analysis, fall firmly and squarely within the coverage of the fair use doctrine. And I would distinguish it, for example, therefore, from something like applying images of collection or non-collection material to t-shirts, aprons, and other merchandising items, where the transformation rationale, the transformative purpose rationale, would be a far weaker one.
So, so what you just heard was think twice, 3 times, and 4 times about putting that thing on a mug. All right, I am going to rush to the end because we have some very important requests for you. This information, you can use this email, although I see that I failed to correct this email. You can use this email or nyoffice@collegeart.org to tell us any questions, comments, things you want us to address in the very last webinar. The very last webinar will be answering your questions. So if we didn't get to something you really want to think about, really, before you leave work today, send a message either to Janet Landay or nyoffice@collegeart.org. The nyoffice@collegeart.org is by far the better one. And so,
let me invite you all to come back next week with any questions that may then have occurred to you in the meantime. And also, do go on to Pat's website or the CAA website and look at the frequently asked questions document, which also has answers, and that we think may cover at least some of the head scratchers that you will certainly be taking away from our discussion today. We're very, very grateful for your time and participation.
Thank you so much for joining us today, and do tell a colleague about the webinars. We'd love for other people to watch the archived webinars. Thank you.